Good morning, everyone. My name is Walter MacCullum, and I'm a principal at Russell Kennedy Aiken Lawyers here in Sydney. I've been a litigator for 21 years now, practicing in Sydney for the whole of my life. A fairly broad practice that I have. It involves most types of contractual disputes, employment, shareholder disputes, franchising, and of course, wills and estate disputes. And that's what I want to talk about today, because there's some peculiar legislation here in Australia that may be of interest to those of you who have clients that may be domiciled in Australia, may be thinking of moving to Australia and ultimately end up dying in Australia, so to speak, or even clients who are executors who are executors of estates that are in respect of domiciled deceased people in Australia. So I chose the title that says, "Even where there is a will, there is a way," to try and highlight the nature of this legislation that is across Australia in every state and territory in its varying forms. And it highlights, for me, a fundamental issue that a lot of people have trouble grappling with, and that is that it has the ability, this legislation, to override testamentary freedom. We all understand that common law right, that everyone should have the right to make a will and have that will carried out once they leave this world. However, in Australia and in other countries as well, that can be undone, and people effectively who have missed out in an estate or receive less than what they want, if they jump through certain hurdles that I'll get through in a second, they can make a claim on the deceased estate and effectively rewrite the will. So I'll just try and see if I can share a screen now as well with you. Okay, can everyone see that?
Yes.
So each state and territory has its own legislation, and there's not nearly enough time today to go through all the 8 variations of this law. So I'm going to give you a very high-level overview of how it works. So if you have so how does one exercise this right, or should I say it's called a family provision claim generally in Australia, and in very simple terms, it's a 2-step process. First of all, you have to pass an eligibility test by falling into one of the accepted categories and to be called what is called an eligible person. So you'll see on the table that I put up there, I've given you descriptors in it, and I must qualify this, it's in very general terms because every state has little idiosyncrasies and its own little tweaking of these types of categories. But you can see how there's quite a broad category of types of eligible people who can make claims. And these categories, I would say, I think in Australia, it's probably over about 105 years we've had it in Australia. I think it started in New Zealand in 1896 and then came into Australia starting in New South Wales. But way back then, it was really only intended to deal with the poor first wife that missed out when the estate was given to the mistress or the second wife. And there are 2 famous cases of famous people here in Sydney that provoked this legislation. But it started at that primary level where the moral obligation and the societal moral obligation at that time was to look after the wife, particularly when the wife had reared children. And that has grown considerably over the last 100 years. And you'll see the categories there. Obviously, the common ones that you'd probably expect to see, people that can make a claim, would be the spouses, the children, de facto spouses, and there's less likely categories, which would be former spouses, stepchildren, adopted children, and foster children. You might also be surprised to think that in certain states in Australia, parents or siblings can make a claim as an eligible person. And as you can see, as we go down into the next categories where it says member of household or people in a close personal relationship at the time of death, I've elaborated on those a little bit more, and you'll see that can be very, very serious catch-all of types of people who can make a claim. And New South Wales probably has got the widest category here, and I think because they started this legislation first, they're probably leading in the broadening of these categories. And there's a big question going on in Australia at the moment is how far can it go? So you'll see those bottom 2 categories there. You'll see, firstly, a person who is in a close personal relationship with the deceased at the date of death can be an eligible person. And that category can catch people such as carers, relatives who don't fall into the other categories, close friends, and of course the extramarital lover falls into that basket as well. The next category is even broader, I would say, is a person there can make a claim if they're either a grandchild or a person that is wholly and partly dependent upon the deceased at any time of the deceased life and also at any time is a member of that deceased person's household. So you can see how broad that is. I've got several cases at the moment where I've got grandchildren who stayed at their grandparents' house, which is quite common in today's times when parents are working interstate or unable to look after the kids, and they end up having a room in their grandparents' house that they stay in, or often there's an estrangement between the child and their parent, and the child goes and stays with the grandparents, and then lo and behold, the grandparents dies, and that grandchild has a claim against the estate. So you can see this category is quite broad, and who knows where it's going to go. So once you've ticked that box and fallen into the eligibility and you've reached that stage, the next stage is an inquiry and assessment that is undertaken by the court as to whether or not the deceased has made adequate provision for the claimant in his or her will. If there's no will and the deceased dies intestate, that's no bar to a claim being made, and the court will then determine whether or not the prescribed rules of intestacy result in adequate provision being made or not. Now, the rules as to intestacy again vary from state to state, but there are various categories of classes of beneficiaries that either get or take parts of the estate, but then there are large numbers that don't. So in an intestate situation, the scope for claims is probably wider. So what it is in very simple terms is that it becomes an exercise in weighing up the financial means and needs of the claimant against that of the beneficiaries, and also often there are other claimants as well. And that's done in the context of the totality of the net estate. So while the various pieces of legislation prescribe and the case law is developed, the court is to take into account many various different factors. Those factors can include the relationship between the claimant and the deceased, contributions made by the claimant to the deceased's growth of wealth. For example, the nephew working in the uncle's business without pay from the age of 16 through to 25. He's developed the growth, arguably a claimant there. And also silent conduct.
Walter, 30 seconds, Walter.
Wow, okay. So that's the process. That really does boil down to a weighing up financially of whether or not someone has a claim or not. And it results in sometimes quite an unfair result where there's a redrafting of the will, overriding the testamentary freedom. So very, very quickly, a court cannot make an order dealing specifically with assets outside the jurisdiction. However, it can take the entirety of the estate into account. So if there are assets here in New South Wales and assets in America, the assets in America can be taken in the assessment of the pool. The other thing to note out as well is that more often than not, the plaintiff is able to get their costs paid out of the estate unless their claim is vexatious. So it is a very fertile area. That's all I can say. Sorry, I've run out of time.